Hi, Business Law and Ethics, Workplace Law Continued, Part 2, Chapter 4. So we will continue on the same objectives we've had on Part 1. We did go into details a little bit on CNESST. I deemed it important that you had this sooner, so I did give it to you sooner, but here is some more information about the CNESST. So we're talking about human rights legislation, right? Restrictions on questions asked on applications and interviews. You have to be very attentive to that. There's certain questions, of course, that we or certain HR or hirers, I should say, will turn around and ask you sometimes very personal questions. And there is a lot of restrictions when it comes to that: race, ethics, culture, marital status, all these things, even pay equity and all that stuff has to be very, very attentive to that, not to reveal personal information. So workplace rules need to be reviewed all the time in light of human rights. This is a continuous adaptation that all societies, all workplace companies, or countries too, will always try to keep up to date on this. As you know, the world changes, and as we all know, the world has extremely changed in 2020, and we can only forecast that in 2021 it'll be more of the same. All right. So continue on Quebec human rights and Youth Rights Commission. So here the Quebec Charter reaffirms the principle of equal pay for equivalent work. So this is why we have the CNESST. It prevents discrimination in hiring and employment practices. Of course, there's always going to be bias in hiring and employment practices. It's always up to the hiree that has to, the candidate also that has to mention it to the CNESST. Okay, so especially with regards to women, absolutely, this is an ongoing thing. Gender equality, we're not even close to getting to gender equality, and hard to say whenever that will happen, unfortunately. Also, members of cultural communities, newly arrived immigrants, refugees, and handicapped, and also Native people. So always we look at the issues related to pay equity, employment, Aboriginal employment, reverse discrimination, affirmation, action. It's a policy in which an individual's color, race, sex, religion, or national origin are taken into an account, to increase opportunities provided to an underrepresented part of the society. A lot of people find this to be the opposite. Affirmative action is kind of discriminating in a sense to everybody. In point of views, you can talk about this in class. Do you believe in affirmative action, or do you believe that the best candidate should always get the job? Not always the case with affirmative action. And also harassments of all kinds in the workplace. There's also quid pro quo. Please ask me what that is, and I will explain it to you in class. There is, of course, unfortunately, I should say, not of course, sexual harassment and also abusive harassment, which comes to sometimes it's verbal harassment too in the workplace. And sometimes there are other harassments that come into play in today's world too, and they keep on getting larger and bigger. And there's always passive aggressiveness there also. Please ask me what that is, and I'll be more than glad to give you some information on passive aggressiveness, and also something that's been around a while, but we just don't know what to call it or name it. It's based on a movie of a long time ago. It's called Gaslight, and a lot of people today in the workplace do gaslight their co-workers. And there's also ghosting. Yes, so many terms. So if you have any questions about that, please write it down and ask me in class. The Act of Accessibility, or Accessible Canada Act, your employees have a duty to accommodate employees with employers have a duty to accommodate employees with disabilities and special needs, absolutely. This they always have to do. The Pay Equity Act in Quebec, you can find a lot more information on this in the CNESST. It is designated, as it mentions there, to eliminate any salary gap existing due to systemic gender discrimination. This is not always the case, unfortunately. It's always up to whomever is being discriminated against to bring this up, right? A lot of these cases just go on because the ones that are being discriminated against just don't call it in, unfortunately. And they should complain all the time, right? Don't feel bullied. And there's another one adding to the list when it comes to abuse in the workplace. When someone bullies you for whatever reasons, or threatens you in a workplace, it is categorically unacceptable, and you need to bring this up. So if your boss doesn't do anything about it, or if it's your boss doing this, your manager, I should say, or if it's you go up to see your human resource manager and they don't want to do anything about it, yes, you can go to CNESST to make a formal complaint. Okay. Now, the Quebec Charter and the Civil Code, right? This is prohibits the invasion of a person's privacy or violation of his or her reputation. Again, with social media, this is getting tougher and tougher to do. So persons operating an enterprise are required by the Private Sector Act to ensure that any personal information on others that they hold or use remains confidential. Well, take it for what it is, but unfortunately humans are humans, and people will take advantage of when they have this type of information to use it against someone else. So be very attentive to what information you do share, even where you work. A lot of information, you'll get a lot of questions sometimes that will be, oh, by the way, tell me about this or all this. Do you still have a mortgage or whatever? Do you where do you live? Or where they know where you live, but more personal questions about who you live with, if they don't know if you're married, and it gets to a little bit too personal. So be very attentive to that. All kinds of personal information. If it's not needed for the work that you're doing, do not divulge it. Health and safety, this is what the original CSST was all about. They added the NE for pay and also for work. But before, it was all about health and safety. It still is. It's a big thing here in Quebec. Safety boards ensure regulations are adhered to. If you find that your workplace, for whatever reason, is not adhered to, and in many cases, if you find that they're making you do things that you're not supposed to, lift heavy objects, work in a very dirty office and things like that, you need to report this. Right, so organization of employees, certification process, what is the difference between associations and unions? If you want to talk about that afterwards, we can talk about that. But before we do that, employees' application to Labor Relations Board to be recognized as a bargaining unit. So majority of workers must be members of the union. So to obtain certification, membership of more than 50% of the workforce must participate in vote, and a majority must support certification. So there is a lot of certainly certified unions in Quebec and Canada, for sure. And if you ask yourself, what is the difference between that and, let me just go one back, and an association? Associations are organizations of people with a common interest or purpose. A union is a type of association with one major difference. Members of a union have the legal right to engage in collective bargaining with an employer. So if you're all teachers, let's say like I am, maybe not, we don't have a union, let's say at Herzing, but if I work somewhere else, there certainly would be a union. Then we can collectively bargain or negotiate for a new salary or a new contract, which is ongoing all the time. So union organizations, trade unions are democratic organizations whose policy is established by vote, always vote, subject to human rights legislation. Trade unions are overseen by labor and obligation to represent all members fairly. Again, Same situation here as everything else. You need to pay attention to what surrounds you, and especially when it comes to unions. It's not necessarily up and always done fairly. Collective bargaining, like I mentioned before, in unions, right? This is where the Industrial Revolution saw workers join together to negotiate wages and working conditions, only because of past owners would take advantage of certain workers and not pay all their workers the same wage or pay them whatever they wanted. So that brought on unions across the world. There was unions, and because of this. So in many cases, though, the union can be hard to live with in certain companies. That might be fair, but unfortunately, that's just the way it is. So the collective bargaining legislation reduced conflict by recognizing employees' rights to be a member of a union, and employer is obligated to negotiate with the union. Again, though, not every company, Quebec or Canada, has a union. So terms of collective agreements could vary. Minimum length is 1 year, though. It may have an automatic renewal clause and or not. It might not be an automatically strike clause. So it's always retroactive in general matter to be negotiated by the parties. In other words, when a contract expires and you negotiate a new contract, you still get paid at the old rate, let's say, or you're under the old contract. But once a new contract kicks in, your retroactive pay goes back to the date of the first day of the contract, when your contract has expired. So mediation and arbitration, third-party intervention and negotiation. When things don't go very well, you will need a mediator. And arbitration, a method of settling disputes and grievances arising out of the agreement. So afterwards, if you do have certain issues in a signed contract, then you'll need arbitration to decide if both parties don't want to budge. And in case both parties don't want to budge, well, then you have two outsets. You have strike, where the company will go on strike and both parties will have to agree to this. Withdrawal of services by employees. And a strike is certainly not in anybody's favor, but if it's done well, strike, usually the company keeps on working with a skeleton staff, let's say, depending on what you have written down. As you can hear about in the news, tell me who's on strike lately here in Montreal. There's a couple of unions that are on strike. Now, lockout, this is a little bit harsher. So this is the action by the employer to prevent employees from working. So if he finds that during whatever reason that he has a skeleton staff and they're working during a strike or a limited time, and they're doing things that they shouldn't be, slowing down the pace, or destroying something, or really doing things that are very negative to the company, then they have the right to lock up, right? Now, when they, or when I say strikes or lockout, this certainly must be given sufficient strike notice. So 90 days after the receipt by the union or employer of the bargaining notice. So they have the power. To have the power to strike is one thing. When a union has the power to strike, when they have the mandate to strike, I should say, they can strike less than 90 days, of course. But it doesn't mean that they will. So they will use that as a tactic. And if it doesn't work out, if the negotiations are not working, then they have the mandate and then they will strike. So must bargain in good faith before the strike. Again, good faith goes a long way. Bad faith sometimes goes a little longer. It's unlawful for a strike or lockout to occur while an agreement is in force. So there has to be no agreement. If there is one, the company cannot lock out and the employees cannot strike. Several severe penalties for declaring or instigating an illegal strike or lockout. Absolutely, on both sides. This has happened many, many times. Illegal strikes where employees just walked out because they just couldn't take it anymore, or for whatever reason, and that certainly is not what you want to do. You absolutely can lose your job. What you should do is look up in the States during President Reagan. when the flight operators, air traffic controllers, I should say, went on strike in the United States. And let me see, I can just give it to you right away. I'll look this up. This is cool. Do that right away. When they went on strike, this was 1981 that they went on strike. And what Reagan did was he just fired everybody. So he fired all the controllers and he replaced them all. So this is, if you could look it up, that was when you defy the president at that time. Certainly they shouldn't have gone on strike in 81, but Reagan fired 11,000 striking air traffic controllers on August 5th, 1981. So think about that, the power of a president and the power of a company. This is, of course, a country, but the air traffic controllers, by going on strike, certainly jeopardized people's lives and also the economy. So he had to take a stand, and he did. He fired them all. So it still ranks as one of the most powerful decisions ever taken on by a president or a leader in the free world. Talking about severe penalties. Okay. So keep going. People involved in essential services may have their right to strike limited by special legislation. Exactly what I was talking about. So still may collectively bargain. Affects police, firefighters, hospital workers, some educators. Substitute compulsory arbitration also. These are all issues that come along when you're negotiating a contract. Now, when you terminate a contract, so the employment can be terminated by either party giving reasonable notice, by paying the notice, the employer given the compensation that should have been earned in that notice period. So immediately with just cause. So they may dismiss an employee with notice for any reason unless it violates human rights legislation. So if someone, even you are unionized or not, your job is not guaranteed if you do some harassment or some kind of issue that you have with someone, of any kind, they can fire you immediately. Also, notice of termination employee must be written before terminating contract or laying the employee off for 6 months or more, possibly. And a contract may stipulate amount of notice to be given. So legislation sets minimum reasonable standard for notice. There is some exceptions I should say. Employee works for less than 3 months. Employee committed serious fault, like I mentioned before. Layoff due to superior force, there's a fire or something happens to the workplace. Contract length expires, and also contract specific tasks completion occurred. Just cause. This is where we get to the important part, but this just cause dismissal requires no notice. Dismissal without notice must be based on employee wrongdoing or a failure to perform the job, including this is with or without union. Absenteeism, tardiness, boom. Disobedience and subordination, out. Incompetency, out. Harassing others, like I mentioned before, drunk on the job, immoral conduct, lack of ethics. These are all just cause and can be terminated immediately, depending on the severity of what they are doing. All right. Nice dog. Also, layoffs, running out of a worker or employer financial problems are not just cause for termination, so reasonable notice or pay is required. So some of these collective agreements and legislation, provincial, provides for temporary layoffs. Illness and disability, we'll finish on this note. Illness may constitute frustration of contract. Human rights and workers' compensation legislation may require the employee to be accommodated. Duty does not apply if resolution of the problem will cause employer undue hardship. Most businesses offer some form of illness and long-term disability insurance as part of their benefits package. So Where disabled or ill workers are involved, every reasonable effort must be made to accommodate them. So many firms arrange for disability insurance to deal with this problem, and human rights, like I mentioned, requires accommodation of employees on other grounds as well, such as family status, religion, and so on, when it would not place undue hardship on the employer. Great. Thank you. That's it.